On the Ag Issues program this morning, a pleasure as always to bring back to the program Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us on the program this morning. Roger, good morning. How are you?
Good morning, Greg. Just fine, thanks.
All right, let us get to it. And I think, for you have seen this the past in recent years, that American farmers have started farming operations in foreign countries, particularly in South America. But there is a provision in the Bank Secrecy Act that is important, and they also need to realize that the penalties are harsh if that particular rule is violated.
Boy, are they harsh. This is something that can sneak up on people. And we've seen this catch some farmers that have started farming operations in Brazil and other parts of the world, but primarily in South America and primarily in Brazil. If you do that, the tendency is you're going to open a bank account there. And that's where the potential issue comes in, because once you do that, there's a provision in the Bank Secrecy Act that really becomes very, very important. And what that says is if you have a foreign account, so you're a U.S. citizen and you open a foreign bank account, or an investment account, for example. But if you have a foreign financial account that has $10,000 or more in it as a balance at any time during the year, you have to report that account to the IRS by the annual tax filing deadline. So there's a form that you have to file by April 15 of each year. Now, a recent case came up on this, and it really kind of clarified the reach of this, and we thought this was the case, and the court confirmed that it is. And the question is, does that filing requirement apply in terms of a surviving spouse once the first spouse dies? Does the surviving spouse still have that obligation to file that form, or be subject to penalties? And that's what the court said in this instance was the case. And so you had an individual, this couple lived in Florida, but he died, and she inherited his foreign bank and investment accounts when he died in 2003. And she didn't learn about the accounts for some time. And so as a result, didn't make the required filings with the Financial Crimes Network. That's the branch of the IRS where this form has to be filed by the annual filing date. Well, once she finds out about him, she gets everything reported. And then she died in 2021, so 18 years later, and the IRS came after her estate for almost $20 million in penalties, claiming that she willfully failed to file the required forms for several years. It took her a while to get caught up. Well, it took her a while to figure out the accounts were out there, and then it took a while to get everything cleaned up and the forms filed. And the IRS said, nope, this is the bright line. We're not going to cut you any slack. There were deadlines that were missed, and the penalties kept stacking up and stacking up, got to $20 million. The court determined that she didn't willfully fail to file, and as soon as she learned about those accounts, she got things cleaned up, so to speak. So the estate escaped having to pay that enormous fine. But it just goes to show you, Greg, that if you have farming activities outside the U.S. and you've got foreign bank accounts, make sure you file this form. It's called a FinCEN 114, and report those accounts or that account to the IRS every year. Because if the penalties are bad, but they're particularly bad if there's a willful failure to file. And now we know they can be imposed on your estate post-death, so it becomes a problem for your heirs. So a lot of people may not have heard about this. It's been around a while, but if you haven't, ask your tax pro about it.
Yeah, definitely. Well, stop me if you've heard this before, that the old adage on reading contracts that you shouldn't sign anything before reading it. And
Yeah.
You've probably got an ungodly amount of stories that you can do on that as well. But there is that necessity of, as always, reading contracts before signing them.
That is true, and this came home to roost for me a month or so ago. I was reviewing a situation for a farmer, and he couldn't understand why the bank was calling his note in. And this was a multi-million-dollar note. Well, he had reconsolidated a bunch of loans with the local bank, and so the sum was just shy of $3 million. And he got a letter from the bank saying, we want full payment within the next couple of weeks. Well, there's no way he could come up with that. And so he's calling and asking, well, certainly this is a phony letter. The bank is wrong. I'm current on all my payments. I've signed this note about 3.5 years ago. We made the first 3 years payments. Everything's fine. What's the deal? And I said, you better send me what you signed. And I looked at it, and I immediately, this is one of these where, oh no, this is so sad. Didn't realize what they signed, and just a beautiful couple, an older couple, just wonderful to talk to, and didn't understand what they signed, and trusted the local bank. And what they signed was a 30-year note, yes. However, there was a clause in there that said, well, yeah, you got 30 years to pay it in equal annual installments with a balloon at the end. But the bank reserved the right to call the note in at any time without cause, without any reason, whenever they wanted to do that. And he signed that, and he also thought that he had a fixed interest rate of 4.25%. Well, there was another line in there that said, yeah, that's for the first 5 years, and then starting at the beginning of year 6, that's going to become a variable rate. And as I talked to him, I said, did the bank happen to ask for any financial information? Well, yeah, they asked for cash flow statement and assets and liabilities. We sent that to them, and then right after that, we get the letter. And so if you put two and two together, a couple of things that people need to be aware of. Your local bank is not going to lock themselves into, for example, a 4.25% interest rate for 30 years, because they're not selling that in a secondary market like a typical mortgage would be on a house. So they're not going to lock themselves in. So always look at that, and then always read it carefully to see if they're reserving the right to call the note in at any time. And that's what happened here. And Greg, I think what happened here was the bank looked at the financials. They're looking at the crop prices. They're looking at the markets, and they're thinking, okay, all right, the farmer made the payments the first 3 years barely. But once that interest rate more than doubles on him, he's not going to be able to make it. We're just going to take the money now. We're just going to cut it. We're just going to ask for it. We're going to call the note in, and if they can't make it, we'll foreclose. Which then really raised the question of what his options were at that point in time. You could get him, perhaps, the best thing you could do is get that bank to sign what I would call a forbearance agreement, where they will forbear their right to call the note in, give him a clean bill of health saying, yep, you're current on all your payments. Then he could take that to another lender and get a loan to pay this loan off that has the really rough terms in it, and maybe get a better loan agreement somewhere else. Bank doesn't have to do that because they hold all the cards, but that'd be great if they could. Or they could mediate it. Kansas has a great ag mediation service, and run that through the ag mediation service and see if you can get a resolution that way. Then the third way, of course, is to file Chapter 12 bankruptcy. But as I explained to them, that'll stop the bank in its tracks, but it also has a downside for you, too. So the message on this one, this is a heart-rendering one. I really feel bad for these people, but make sure you read what you sign. I can't emphasize that enough, or take it to somebody and have them read it and analyze it for you. It's very, very important before you get yourself bound into something like this.
Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, is our guest on the program this morning. And Roger, it's fair season, which means, of course, plenty of 4-H sales that are going on across the state of Kansas. But you make money, you have to report it as well. And you've got some tips on proper reporting of 4-H fair sale income.
Yeah, I get this question this time every year, Greg. Multiple times I get it during this time of the year, and that is when you do sell a 4-H or an FFA animal at the fair, where do I report the net income? And the answer, as it is in many tax questions, is that it depends. Well, what's it depend on? It depends if you're a farmer or not. And some of the kids may be active in a farming operation. Some may not, but that's the key to answering the question. So the net income of that animal's sale, those proceeds, they should be reported on the other income line of the 1040. And there, it's not subject to self-employment tax. And that's the case if the animal was raised primarily for educational purposes and not for profit, and was raised under the rules of the sponsoring organization. And if it's not subject to SE tax, then it's not earned income for kitty tax purposes. On the contrary, if the animal was raised as part of an activity that the seller was engaged in on a regular basis for profit, then the sale income should be reported on Schedule F, where it's going to hit self-employment tax. And that's also true if the 4-H or the FFA member has other farming activities. So that's the basic rule. There are also some other considerations. If you want to start an IRA, for example, with the sale proceeds, the income has to be earned income. You need to be paying self-employment tax on it in that situation. Are you trying to build up as a young person? Do you want to start paying into the Social Security system? Same rule applies there. Well, is it tied to a farming activity or not? So 4-H, FFA projects, really good stuff, valuable life lessons for the kids that are in it. But we got to worry about these tax rules, unfortunately.
Yeah, absolutely. All right, let's move on here. And of course, many people, and especially if you're involved in legal cases, know that there's protections of the attorney-client privilege, and especially communications between the attorney and client. But you've got some exceptions to that, specifically looking at crime fraud.
Yeah, this is one that came to me 2 or 3 weeks ago. I had an attorney that wanted to share his story with me, and he was totally caught off guard by this. He was representing a client in a Chapter 12 bankruptcy, advises the client in terms of what he can do permissibly within the law to protect as many assets as possible in a Chapter 12. And client didn't follow that advice, did some bad things, ends up getting prosecuted by the Department of Justice. And the next thing the attorney knows is he's hauled before a grand jury as a person of interest. The client was a target of the investigation. He's now a person of interest, and they wanted the letter that he wrote to the client, and they wanted other client communications. And he said, no, I don't have to give that to you. That's protected. And he learned kind of the hard way, no, that's not protected. Because if the advice you give is used in furtherance of a crime by the client, then those communications are unprotected, and then you can become a targeted individual by a grand jury. And that's not a good position to be in at all, to get hauled before a grand jury, let alone be be a target rather than a person of interest. Long story short, he had to divulge the information. It was not protected because there's that crime fraud exception to that attorney-client privilege. But the court looked at that and said, well, if the client would have followed what you told them, they wouldn't have had a problem. So he was in the clear, but he was surprised by that. And I think for our rural attorneys that are listening, we can get into that issue. Whenever there's legal advice given to protect assets, whether that's in the bankruptcy context, Chapter 12 bankruptcy, or whether that's for Medicaid planning purposes, those are the major issues, major areas where that issue can come up.
One final thing that I want to talk about, and especially for those farmers and ranchers out there, if you have a farm employee, I'm sure the question has come up, but what's the extent of your liability exposure? And also, what steps should you take to minimize those potential legal problems?
Yeah, this is an issue for a lot of farming operations that have hired hands or employees. They're always concerned about what's my potential exposure if the employee is injured or causes an injury in the scope of their employment. And that's a key point there, because if they're acting on their own or outside the scope of employment, then as an employer, you're generally not going to be responsible for any injuries or damages that they cause. So that would be the first level of the analysis, is what were they doing? Was it in the scope of their duties for you as the employer, and what can I do to protect myself? This issue came up recently in a court case. This is out of Texas, and we had a young man here that was killed while riding an ATV driven by the teenage son of the farm operations employee. So it wasn't the employee's son, it was a friend of the son on the farm ATV. And the accident occurred off the farm premises during a fishing excursion. These are two 16-year-old boys that took the ATV off the farm premises, and they went fishing with it. And one of them ends up falling off and getting killed. And the farm owner was sued for wrongful death based on the principle of negligent entrustment. You entrusted your employee with the ATV, then the employee allowed his son and a friend of the son to use it off the farm premises, and that's when you had the disaster that occurred. Well, the court said no. Both the trial court and the appellate court said no, there was no negligent entrustment because there wasn't a special relationship between the teenage son that drove the ATV and the farm. He wasn't an employee. The accident occurred while the ATV was being used for personal purposes. It wasn't being used for business purposes. And the courts also pointed out that the farming operation, the farm owner, didn't know or have reason to know that the employee's son was an unlicensed driver or didn't know how to handle an ATV. So, Greg, we've got to be really careful in these situations as farming operations to carefully train employees on how they are to use farm equipment, farm machinery, and vehicles, including ATVs. And it's always best to have a written guide. Put things down in writing as to what your expectations are. The larger operations should have a formalized employee handbook. And that's always a good idea. And address those issues, such as off-farm use by family members, and even address issues such as proper attire. Those are things we get into in agriculture. We're constantly working around moving parts and gears and all types of things like that with respect to machinery and equipment. So we don't want loose-fitting clothing. We don't want sleeves that are baggy or pants that are baggy that can get caught in things. We don't want long hair or jewelry. Just kind of think through common sense things like that and make it a part of the employment agreement. I know a lot of farming operations don't do that, but these cases, when we see them, really point out how important it is to do that to protect yourself.
All right, Roger, we are out of time, but as always, great information. And if people want to learn more or want to read up on anything or keep up to date, they can always go to your blog?
That's right. These topics are posted on my blog, washburnlaw.edu/WALPR, and also over on Ag Manager at K-State.
All right, sounds good. Roger, as always, very much appreciated. Thank you very much.
Thank you, Greg.
That is Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us this morning on the Ag Issues program here on 580 WIBW.